Hello there, my name is Lamin Jai, and this is a special interview with the chairman of the Constitutional Review Commission, Justice Cherno Sulayman Jallow. 2 weeks or so ago, the journey of the draft constitution, which seeks to usher in a new republic, or birth a new republic, if you like, suffered a blow after members of the National Assembly voted the bill that really sought to ensure that the country moved to third republic. There suffered that setback, and the members of the National Assembly voted it down. We are here with the chairman of the of the commission, the man who was hired to really cobble this document together, Mr. Justice Cherno Sulayman Jallow. Justice Jallow, thank you very much for speaking to the Fatu Network.
You're most welcome.
First of all, this is a very important development there. One would not really say that it is that, but what we can say safely is that the document has suffered a big blow. Did you see this coming?
You know, when you embark on a constitutional review process, you bear two things in mind. First, you have to realize that it is a legal process on the one hand, and on the other hand, it's a political process. And it involves a number of stakeholders. In our case, we were guided throughout the process by a law that was set down for us by the National Assembly, which was assented to by His Excellency the President of the Republic. Now, we use those guiding principles and to make sure that we sought opinions and made sure that we considered those opinions properly and incorporated those that we felt represented the views and aspirations of the Gambian people. So yes, in a way, you could say that one could see this coming. It was always a possibility. We never discounted that out. But our responsibility was to discharge our mandate, which was to review the 1997 Constitution and write a new one. And in so doing, we followed the processes that were set out for us. And we've tried as best as we could to be as balanced as possible, looking at international best practices, and bearing in mind also the importance of ushering in a new constitution that could withstand the test of time. Because it makes no sense that every time you have a change of regime, you embark on this process. It's costly, it's time consuming, it's resource constrained, and several other factors that have to be looked into. So am I surprised that it suffered the fate it did? Absolutely not. Obviously, all of us would have welcomed a different outcome because nobody sets out on a journey just to be stopped on your tracks. You would expect that you would complete that journey right to its conclusion. But like I said, this is both a legal and a political process. With the legal process, as far as I'm concerned, we had completed that. We would discharge our mandate under the law. What was left was really for the elected members to take the process forward. And I think that's where the setback occurred.
Now, yesterday you held a press conference to speak on this issue for the very first time. Mm-hmm. You said that you are satisfied with the product of your assignment. That is your work. You did it to the best of your ability and you were satisfied. However, you came short of taking a position because what much is out there has to do with people, or the entire Gambian people and institutions taking positions as to whether members of the National Assembly are right or wrong in rejecting the draft constitution. You kind of played safe. You said you don't want to question parliamentary wisdom. Why didn't you take a position given the fact that you are part and parcel of this political process, and it is this commission that was established, set up, or hired to do a job? Now, if that job fails, for the sake of accountability, it will be very important for your committee to explain and as well take a position.
Well, I'm not sure that it is more a question of taking a position, because the only position we could take is that we discharged the mandate that was reposed in us. And that was to review and write a new constitution and provide a report in relation to that draft constitution. At that point, and I did make this very clear in my statement, at the point at which we delivered the draft constitution and the accompanying report to the president, that was where our mandate ended. Whatever occurred with regard to the draft constitution was outside of our remit. There wasn't anything we could have done. There wasn't anything we needed to do. So it became a political process. It needed to go through the executive, through the legislature, and had it passed to the people for a referendum. As far as positions are concerned as well, the people in particular, they've taken a position. The people have taken a position during our consultation process. If you look at our report, we outline what the people said in respect of every particular subject matter, particularly those key ones that found their way into the draft constitution. That represented the opinion of Gambians. You and I may not agree with them, but they represented the overwhelming opinion of Gambians. So that was what we incorporated in. And you see, we had to lay down specific foundations from inception. If the law mandated us to consult Gambians at home and abroad, and to take their views into account, their views and aspirations into account, to the extent we considered possible, that was a discretion vested in the CRC, and we had to discharge that discretion in a very judicious manner. And that was what we did as far as we were concerned. Obviously, people will, who hold contrary opinions will say something different, but we were the ones involved and engaged in the process. We knew the rules we laid down for ourselves, and I, as chair, always made sure that we kept to the rules we established for ourselves. No personal opinions from outside, and our opinion could not override public opinion. So the public's opinion, the position the public has taken, is effectively what is in the draft constitution. There are a few areas where the public said we wanted this, and we thought it could not happen because of social and economic factors which the public might not have been aware of. And we included that in the report. And when we went on the second round of public consultation, we brought those out to them. Because I was very clear, and the entire commission, we were very clear that wherever we departed, we needed to go back. In addition to telling them what we incorporated, we needed to tell them where we departed from our opinion. There are a few areas, and when we explained that to them, they said to us, we are fine. We did not consider the points, the ramifications you've outlined, but what you outlined is fine, and we accept those. So generally, the public has a position on the draft constitution, and that position is what is reflected in the draft. So yesterday there wasn't anything more, like I said, that the CRC needed to do. Our responsibility was not to take a political position.
Not necessarily a political position, because I want to insist on this further, because if you look at the opinion that is out there, you have some opinion that point fingers of blame at the CRC, that you did a very bad job. That is what led to the draft constitution bouncing at the National Assembly. What do you have to say about that? The fact that this draft didn't go through because of the work that the CRC did wasn't the best of works.
Well, people are entitled to their personal opinions, and one can't fight with that. That's the nature of democracy. But the fact of the matter is, a lot of questions that have been raised in relation to the draft constitution, we were never afforded that opportunity publicly to go to the National Assembly and assist members in providing clarifications and in answering the questions that they raised. And we were the people who were best placed to provide that assistance. So yes, people are saying so many things, but we are sitting and we say, but we have the answers. But we cannot go out on our limb, out in the public, trying to answer everyone. It becomes a national debate then, and that's not what we should be engaged in as an institution. As an institution, the CRC Act provides that the National Assembly may request us to attend before them to assist either by clarifying issues or by answering questions. What we had expected would have happened was that it would have gotten to the stage where we could be invited to provide those answers, to provide those clarifications. The National Assembly still had an opportunity to reject the draft, but it did not even get to that level. So yes, there will be speculation. People will say, those who are against the draft constitution for their own various reasons would obviously criticize the CRC, will criticize the draft constitution. But I think if you look at it from an objective perspective, quite a number of people, quite a number of people thought this was the way to go. This is the draft constitution that the country asked for, and people told us that. This is whatever you wrote there. We asked you to do it, and that's what we placed there. But that doesn't mean that there won't be critics. There will always be critics, and we've gone beyond that stage now as far as we are concerned. We discharged our responsibility. We subjected the draft constitution to internal review. You would have been privy to all of that. And we subjected it to external expert review. Different institutions, different experts, including professors of constitutional law. And the final product, actually is a validation of what they themselves said to us, that you have one of the best draft constitutions in Africa.
And yesterday, in your statement, three things stood out, really featured highly in your statement. Mm-hmm. One has to do with the issue of plagiarism, your commission being accused of going out there and plagiarizing other people's constitution. Mm-hmm. But what you advanced in your statement was that it is perfectly okay to copy other nations' constitutions so long they are relevant to your own context. Why do you think so?
It's not a question of whether I think so. That's what happens in writing laws. Depending on the subject matter, you could be original in terms of the drafting. And you will find a lot of original provisions in the draft constitution. And nobody seems to make reference to those. But also you look at what constitutes international best practice. And international best practice is gathered from the laws that other countries have in place, and then you look at, you make a comparative analysis. How many countries have provisions like that? Which have the latest laws on that particular subject? What are their, what have they done to improve on particular subject matters? So it may not be necessary. When you look at those provisions, you come to the conclusion, and this is a professional judgment you make. Does it make sense to change the language? Or is this very clear? If it is very clear, you take it. You either adopt it or you adapt it. Make a few changes here and there, depending on what it is, to suit the circumstances of your country and the subject matter you're dealing with. That is what legislative drafting entails. You can, for example, look at literature. Drafting involves what we draftspersons like to call drafting instructions. You have to have instructions on what to do. You cannot just instruct and say, write a constitution, and then that's the end of the matter. No. We had to do our research. We had to identify subject, which is why we had our issues document with 369 questions, so that the people can tell us or can share with us what their thoughts are on those particular issues. And from those, we were able to formulate drafting instructions. And in addition, we were able to look at international best practices that is contained in different constitutions around the world. And we looked at the Commonwealth, we looked beyond the Commonwealth. So like I said yesterday, I have never ever, in all my years of drafting, heard of legislation being plagiarized. That only happens in this country, because it's perfectly acceptable to adopt or adapt legislation from elsewhere. In fact, a good number of legislation that are enacted by the National Assembly are not necessarily original. You know, these are ideas that are contained, for example, in UN instruments, treaties, conventions, could be regional instruments, could be international. They could also come from studies that somebody made. Or it could be a subject where you yourself as a draftsperson need to say, okay, let me see how country X dealt with this particular subject matter. The important thing is that you need to adapt it to suit your own circumstances. And that is what we did.
That is what, but clearly what it did, this approach, what it did in this country, it sparked controversy. As a draftsman, could you have done it in a different way? It is perfectly okay for wisdom to look alike. You know, one person thinks this way and another person thinks the same exact way,
yeah,
and
but,
it will suit their circumstances.
just because of one opinion, just because there's one opinion that feels that this is what they call plagiarism, it's not going to change my professional approach to dealing with the subject matter. Like I said, I'm a trained draftsman. My critic out there who says it's plagiarism is not a trained draftsman, doesn't know anything about drafting. All right? If you look at a lot of these instruments, all right, they actually benefit from the values of other countries. You see, one of our consultants is a former Chief Justice of Kenya, Justice Willy Mutunga. One of the things he said to us on this particular subject is that the provisions you took from the Kenya Constitution actually rescued, and the way you handled it, rescued our own shortcomings. And that's what you do. You see, it's good.
Did you believe him when he said that?
I'm a draftsman, I know that's true. I mean, that's what you do. When you look at legislation from a particular jurisdiction, it looks good, but you could make it better. Take, for example, a good example in the draft constitution. And this was borne out when in our discussions on gender parity. How do we go about that process? We were very clear that we wanted the marginalized groups, the youth, the women, persons with disability, you know, to be given some special dispensation, some special attributes within the draft constitution, so they can also participate in a democratic process. And when we look at statutory bodies, the state enterprises, you know, what we call the parastatals. One of the things we came up with, okay, we have the term limits for chairpersons, or where you have deputy chairpersons that as well. And we said, you know, we could make this provision better by ensuring that if you are chair of a parastatal and you are male, your term comes to an end and you have to demit office, your successor has to be a woman, cannot be another man. You don't find that anywhere, you know. And when we came up with the idea, our consultant said, hey, that's brilliant, you know. And they said they wish, even now considered they could do something like that. And there are quite a number of those innovations. And yesterday I outlined quite a number of the innovative provisions. I want Gambians to understand and that legislative drafting is a special skill. It's a difficult one too. That's why you don't have so many draftsmen in the Commonwealth. This issue of plagiarism that's being bandied around is just to stoke emotions, you know, to support a particular position for rejecting the draft constitution. That's the only way I can see it. But for us, you know, and we decided from there we were not getting too deep into that, you know, because we were satisfied with what we did. Like I said yesterday, if you look at the Constitution of Kenya, it borrowed a lot from the Constitution of South Africa. If you look at our 1970 Constitution, it was practically the Jamaica Constitution of 1962. If you look at our 1997 Constitution, it drew so much inspiration from the Constitution of Ghana. And I can go on and on and on. So this is the way it is done. And I've never heard anybody say the 1970 Constitution was plagiarized or the 1997 Constitution was plagiarized. But the other factor is, we did not only take provisions from Kenya, we took provisions from Malawi, from Uganda, from Nigeria, from Ghana. We looked at the best that was there, and we improved on those. Where something wasn't available, where we needed to craft, we crafted it on our own. We did all of those things. That's how constitutions are built. That's how good laws are built.
Now, but my question now is, these consultants or experts that you are talking about, these experts that were advising you, how did you arrive at trusting them this much, to the extent that whatever they tell you, you agree to? Because clearly these are people that do not really understand our climate, our context. These are not people that have any special expertise in the Gambian in the Gambian context or in the Gambian climate, if you like. So how did you arrive at trusting them to the point of whatever advice that they give you, you agree to?
I think the question is a bit misleading, because it's not like they were telling us what to do. We were the ones coming up with our initiatives. And where we felt we needed their opinion on, we sent it to them. That's how the process worked. It was not them telling us, do it this way or do it that way. That was our initiative. We just sought their opinion. All right? But the other thing is, these are experts, and they don't need to be here, to know Gambian law or anything like that. That was our responsibility. They come from backgrounds, from jurisdictions with similar legal systems. Take a look at the Nigerian legal system. Look at the Ghanaian system, the Kenya, the South Africa, the Malawi. South Africa is slightly different because it's mixed Dutch common law. But if you look at the rest, we have practically the same legal system, which is why, for example, in the court system, we regularly make reference to cases from other Commonwealth countries. We rely on them. Lawyers rely on them to make their arguments in court. And judges writing judgments rely on those and make quotations and then arrive at decisions based on decisions made by others. Is that plagiarism? No.
Were there moments when you disagreed with these experts, like in terms of their opinion?
Oh yeah, they did make some suggestions which we felt we couldn't accept, and they were okay with it because they knew the final decision rested with us.
Can you give us specifics, like the moments when you really disagreed with these experts?
I don't think it's a question of disagreeing. I think it was more a question of asking them what their opinion was on a particular subject matter, and they're telling us, oh, this is what we think. For example, we had this very serious debate on secularism. And, we sought opinion. In fact, I sent out, because we had a lot of people outside, we were consulting with. We did so much research within country. After the first round of public consultation, I thought it was best to invite independent opinion on this matter. And the feelers that went out all came with a position that was completely that completely supported the position we took, with the draft constitution. And they came up and said, okay, these are the solutions if you want, since it's such a big problem. We looked at all of them. We even got some internally, but we turned down all of them because we thought they didn't go far enough in resolving the debate over the issue. And we formulated our own provisions. Which is why you find the language that is there on secularism within the Constitution. And in my personal view, those provisions that safeguard religious freedom, that ensure that all faiths in this country are treated fairly, you won't find that in the 1997 Constitution. It's not there. So we went miles, I can tell you, to make those changes, to sit down and say, look here, this is our own issue in this particular context. We don't think any of our consultants, we don't think any of our external institutions got it right on this. So we departed, and we developed what we thought was the best under the circumstances.
The other issue yesterday that you also addressed has to do with the issue of the draft constitution permitting in some quotas what they would say happened, that this draft constitution permitted gay marriage. Well, that also proved contentious, and you addressed that issue saying that the draft constitution should be interpreted conjunctively and not disjunctively. But
Yeah.
was it possible at all for this charter or the draft constitution to be explicit enough for the layman to really understand that that was really not the case?
We thought we did that in the draft constitution. If you look at what is in the 1997 constitution, it's section 27. It has two subsections. All right. One deals with the right of a man and a woman to marry, and the other one says the parties. You know, that marriage shall be with the consent of the parties. And I'm just paraphrasing. Now, people used that and said it permitted gay marriage. You know, and we were like, no, it doesn't. You have to read subsection 1 and subsection 2 together.
Yes.
All right?
Yes.
So that was why I said you need to read them conjunctively instead of disjunctively. If you take subsection 2 and read that apart from subsection 1, it will give you that impression. But that's not how you interpret laws. So you take them holistically.
But so clearly, it's very difficult for the layman.
Yeah,
the layman would not be able to know that.
Which was why, in the draft constitution, we dealt with it differently. We said every man and woman has a right to marry, and such man and woman, such marriage shall be based on the consent, on the free will and consent of the man and the woman. So, unless people are telling us man means woman or woman means man, which I don't see happening, you know, I don't understand it. Which is why yesterday I said I could not analyze it better than Foroya did in their newspaper on the 28th of, in their editorial of 28th of September, because they made it very clear, you know, and which was precisely why I said yesterday, I couldn't see by any stretch of legal interpretation how you could interpret section 54 of the draft constitution as permitting you know, gay marriage. But that aside now, that's historical at the moment. We are stuck with the 1997 constitution. We are stuck with section 27, which everybody said allowed gay marriage. So now what's going to happen? Are they saying that that's no longer gay marriage? As a country, sometimes I find these debates very interesting. I mean, we say one thing on the one hand, and we try to improve it. You say something, but you go back again, and then everything goes quiet. You know, but this one, you know, I'm kind of surprised to hear people saying that Section 54 allows gay marriage. I still can't understand that.
You still can't understand that. Now let's talk about the money part. 116 million was what was spent on your project, and you said yesterday that you are encouraging Gambians to not consider it as a waste. Why do you say so?
You see, when we embarked on this constitutional review process, we, frankly speaking, we did not expect the level of interest that we witnessed. When we started this process, Gambians became glued to constitutional review. Every place we visited, every bantaba we held our meetings at, people turned up in their large numbers. It was so encouraging. And we had fruitful discussions. We did not talk to them, we talked with them. We involved them. We outlined the draft constitution to them through the National Council for Civic Education, which was the advanced team. We went there to explain what constitutional review is, what they should expect us to be asking them. So people had an opportunity to get together in many instances to discuss those issues. So when we got together, they asked us questions, we clarified, we received some of the original positions, or at least all the original positions they stated to us. They were coming up with brilliant ideas. Yes, some of them were coming with ideas that were not constitutional in nature, but it just shows you the level of engagement, people were very interested. And I believe I made this statement yesterday, that in some communities they were telling us they were so pleased with the dialogue that they said to us, can we come next year and every year so we can have this kind of discussion? We never knew what the Constitution was about. We never knew, we had rights, that nobody can interfere with, and things like that. So they were extremely pleased. So the constitutional review process has been a very educative process. People have learned so much, and the people have developed ideas that have helped us as a commission. Things we never conceived, never thought about, and never would have had we just sat in our offices to write a new constitution. So we imparted knowledge, we gained knowledge, and that helped us to write a constitution that we thought was fair and balanced. So people should not see it as a waste of money. I can understand the public, the public feeling that after all this amount of money, the constitution is rejected. I can understand that feeling, and I can relate to that. All right, but I would want to encourage people to look at the positives. Sometimes we tend to look too much at the negatives. Let's look at the positive. In as much as we may want to criticize the process, in as much as we are dissatisfied with the outcome, I think ultimately we should not lose sight of the fact that our people have learned so much. So in a way, I don't think it's a wasted process. It didn't get to where we would have loved to, but I was.
And don't you think that's where the problem is? Because the main objective was for this project to deliver a new republic, where we would completely break away from the past, and only a new constitution could see that happen. Don't you think that is where the frustration lies mainly, and not necessarily the fact that people learned a lot from it?
Yeah, you're absolutely right. I think what I'm saying about people learning it a lot and things like that, some people will just dismiss and say, look here, we didn't get our objective. People were actually looking forward to a referendum, I can tell you that. From our pre-consultation to our consultation process, people were telling us, look here, in the past, we've participated in referenda, but we never knew actually what we were voting for. People tell us vote yes and vote no. If you voted yes, you were for the government. If you voted no, you were for the opposition. This is not me saying it. This is what people were telling us, And they said for the first time, they were being involved. They knew what they were being involved to participate in. So when it comes to a referendum, they would know how to vote. So in other words, they moved away from the position in the past where they were told vote yes or vote no, to a position where they now know if they are to vote in a referendum, how they would vote. Nobody will tell them vote yes, vote no. Even if you campaign on those bases, they will still know what they were voting for. In the past, they didn't. So I think, yes, the frustration is there. People had hoped that the draft constitution will go back to them finally, so they can give their verdict. If they needed to validate it, they will validate it. If they needed to reject it, they will reject it. And that's what we all had hoped. And yes, you are right. That's where the frustration is. But what I'm saying is, in as much as that frustration is there, I think we need to recognize the fact that people have learned so much. The participation itself is what is generating all this debate now. If we had not engaged this open, public, inclusive, participatory, democratic process, we wouldn't be having this debate now. Or it would have been, just amongst academics. The ordinary man in the street wouldn't be interested. But your crew can go out to the street today, and I'm sure you probably did that already, asking people, go to the market, ask market women on the streets, taxi drivers, ask them what they think about the rejection of the draft constitution, and you will receive an opinion.
Of course, certainly.
It's because the process has been inclusive. It's been so open. We've been very transparent about it. So people need to learn that in as much as we are very disappointed, we must also admit the fact that we've learned so much. And the draft constitution being where it is right now, may not necessarily be the end of it. You know, we should still continue the process of engagement and participation with the view of ensuring that ultimately we get what we desire, what we have been advocating for, and that is a draft constitution which will usher this country forward and in a better place.
In a better place. I know, I mean, you've classed your critics as being in the minority, and the fact that you have people that have never said anything good about the CRC, your commission. But as soon as you finished your press conference yesterday, some of your critics came out again, and they came after your commission. I want to read out what one Gambian journalist said when you talked about the fact that Gambians shouldn't consider the amount of money that has been spent on this exercise as a waste. And this is what he said: after wasting $116 million on a document only thrown in the trash, instead of apologizing or be accounted for, they still have the guts today to face Gambians and said they are living with their heads high up. High up for what? What did you produce for Gambians? Nada. Isn't that a shame?
Well, that's a personal opinion. And, like I said, people are entitled to their opinion. One thing I said yesterday during the question and answer session was that in all the debate that is going on, I haven't heard anybody say we haven't followed the letter and spirit of the CRC Act, which was effectively our guiding document. We followed every single rule that was laid down in that particular document. We produced a document that represented the wishes and aspirations of the Gambian people. Obviously, in so doing, it involved cost. That's natural, all right? It involved cost. The mere fact that that document was stopped in its tracks is no fault of the CRC. Others may disagree, but the law is very clear what we were mandated to do and where our mandate stopped, and who takes over from there until the process gets to a referendum. So are we proud of our product? Yes, we are very proud of it. But we are, above all, very proud that it represents the wishes and aspirations of the Gambian people, irrespective of what others might say. We were the ones involved in the process. We were the ones who went around. We listened to everybody. So we know what people were saying. We know what people's, what people's aspirations were and how committed they were to those aspirations. So we can only hold our heads high. We did absolutely nothing wrong. We did what we were charged with to do, and if you are charged to do something and ultimately a political process stops that, why should you be ashamed? We have other commissions going on around. People are not satisfied the way the outcomes or the reports were implemented. Should that soil the professionalism of those who authored the documents? No, I don't think so. I think we need to get away from the blame game, and accept the fact that, and look at it in a very objective way, that you are assigned something to do, and you did that to the best of your ability. And the mere fact that that is not implemented, which is completely out of your hand, does not make you guilty of anything. If anything, you can only hold your head high and be proud of your product.
How about, what do you make of the people that sympathized with you? You said people sent you messages of condolence to kind of like condole with you. What do you make of that? The fact that some people were so devastated by this development that they sent you messages to condole with you.
I think that's the word. A lot of people were devastated, and people expressed disappointment. I received so much of that I will never share it publicly. But again, it's the level of frustration that people had, because people were optimistic. For the first time in the history of this country, and I believe I said this yesterday, we had an all-inclusive participatory process in constitution building. And for the first time, if memory serves me well, the National Assembly was involved in that process. But for the first time also, the National Assembly rejected the draft constitution. This will all go into the history books. You know, yes, people are frustrated, people were devastated, you know. That is not all, because it depends on, you know, on which camp you belong to,
or you see things from,
or how you see things from, and that's in the nature of constitution building. We all cannot agree on the same thing. You see, constitution building requires sacrifices. If you look at the way the American Constitution was developed, you had two great leaders, Franklin and Roosevelt. And also Woodrow, rather. And when they stood up on the platform, when the Constitution was being debated for acceptance, they all expressed dissatisfaction with the draft, with the draft Constitution. But they made it very clear, each one of them individually, that if they were to substitute their own ideas, they didn't think that would be enough to make the document better. So they would accept the document with all its imperfections, with the hope that it serves the country well. So they sacrificed their personal ambitions. They sacrificed their own views, their own aspirations, because they felt it was necessary to move the country forward. And that's how you deal with constitutions. If we were to accept every opinion given to us to incorporate into the draft constitution, trust me, you and I wouldn't be having this conversation now, because nobody would read it. You know, it will become too humongous. It wouldn't make sense, and it will be difficult to reconcile some of these things. Constitution is supposed to provide framework. In this particular instance, we took one deliberate step, which was we would not leave too many things. In fact, if we could, we wouldn't leave anything to interpretation. We would try to be as clear as possible and as simple as we could, because that is our aim. We were not out there to produce a constitution that was going to be a lawyer's document. We are out there to produce a constitution that was going to be a people's document, and people should be, who can read and write, should be able to read and understand the draft constitution. So that was our aim. So we used different approaches to this.
Now, I want to ask your opinion. I know it's very difficult sometimes to get things from lawyers when they don't want to say anything on something. But give me your personal opinion on the claim that the draft constitution was a victim of partisan politics. Because I mean, this was something that I was there and I could see partisan politics very much at play. So, and because of this, the draft was rejected. What do you make of that claim? That you have Camp A versus Camp B that were involved?
Well, I don't know anything about the camps, and I wouldn't want to get into that arena. But, you know, I think the reality on the ground, as we have seen it, as we have witnessed the debate, and I did make this, statement yesterday, very honestly, I think the draft constitution fell on the altar of political convenience, and again, CRC cannot be blamed for that. I mean, that was not within our mandate. We had a responsibility, the executive had a responsibility, the National Assembly has a responsibility. Ultimately, the people have a responsibility. We finished ours, we gave it to the executive. The executive looked at it, passed it to the National Assembly. National Assembly is the one that stopped it in its tracks. So it didn't get to the people. So there is absolutely no way we could take a responsibility for that. But yes, absolutely. I mean, there are all of these processes, and whether there are different camps or things like that, that's a matter for public debate. But it's not something I would really want to go into, because I will just be speculating.
You'll just be speculating.
I don't want to do that.
But one man that was clearly in the heart of and the center of this all is the president. Mm-hmm. Clearly his camp. The president himself was never satisfied with this document. You could see that from his ministers, from MPs that are loyal to him. You could see it everywhere. And this is the man that hired you to do this job. And you are saying you did your job to the best of your ability, only for it to get to a point where you have the president who is complicit in its failure. How did you feel about that?
Well, I am not going to get into all those statements, whether he was complicit or whether he's behind it or anything like that. It's not something I can speak to authoritatively, but I can tell you one thing: what we've seen in the recent weeks and maybe months leading to where we are today, there have been a lot of dissenting opinion to what we have in the draft constitution. Without going into what we discussed with any particular individual or institution, the fact of the matter is we did receive representations from people, from institutions, from the
Office of the President?
From the three arms of government, and we did discuss their views with them. And as I said yesterday, we accepted some and did not accept some, because we were following our mandate under the draft constitution. This was a draft constitution meant for this country today and going into the future. It was a draft constitution that looked at our international obligations under the various treaties. It's a draft constitution that is benchmarked against international best practice. It's a draft constitution that took primary consideration of public opinion, as we were mandated to do under the CRC Act. And we had to create that balance. If, for instance, let me use you as an example, express an opinion, sensible opinion, very solid, but 90% of this population said, no, we don't agree with Lamin. You wouldn't expect me to go with you. What I can do, depending on the nature of it, I can try to safeguard your fears by some mechanism within the draft constitution, and we've done things like that. And I use a good example, for instance. For the first time, we have in the draft constitution that ministerial appointments should be confirmed by Parliament. And that is designed to ensure that Parliament assists the executive to get the right people. But we took into account that Parliament can be too political as well. Yes. All right? But that in itself was not sufficient to move away from that principle, because this is the emerging democratic process in all parliamentary, in a lot of parliamentary democracies. What we decided to was to put in a provision under the chapter on the legislature to indicate the process for confirmation. What is the objective? What should you do? And to require the National Assembly to provide standing orders, rules on that confirmation process, so that it is not used as a political ping-pong. Every time the president sends somebody's name forward for confirmation, the three branches of government are supposed to work together properly. But if you look at the current atmosphere, one may argue that that's not going to happen. It's not realistic, because we have a very polarized parliament. And I'm not saying that.
That's the fear.
I'm just saying. But the thing is, we cannot measure what is best for tomorrow by just one simple standard of today's. And this is one of the other difficult areas of drafting. When you draft laws, including a constitution, you try to cater for today's circumstances and for tomorrow. If you look at the parliamentary history of this country, over time, back since we got independence to where we are today, I'm sure you will say we have a better parliament today. We've seen improvements. We've seen improvements over time. Now, we ought to cater for the process whereby going into the future, we will have parliaments better than what we have today. So you can't use today's circumstances as the yardstick, for benchmarking your draft constitution, because then you are not looking into the future, and you'll just be stuck in the past.
And the thinking has to be progressive.
It has to be progressive. It has to be transformational. You have to do that. This is all part of constitution building. Otherwise, all you are doing is just taking a constitution, looking at today's circumstances, and tomorrow hoping you can, do better.
Fair enough, yeah. Chairman. But Chairman, also, have you heard of the claim that you were all this time out there serving a particular group's interest? Have you heard of that claim?
Yes, somebody mentioned it to me. I'm not on social media, so those on social media have been telling me that, and I just told them to get off social media because they're going to confuse themselves. No, it is not true. I think, and I will challenge anybody in this country who knows me to have any link with any particular politician or any political party to come forward and say so. I'll challenge anybody.
Now,
I'm not partisan. I'm not partisan in this process. I have absolutely no political interest. There was only one interest, and that's the interest of this country as mapped out for us under the CRC Act. And I can speak to that any day or time.
I will put something to you now, because this comes from Honorable Samba Jallow, the minority leader, probably the most powerful MP in this country. He's the minority leader. And clearly he supports President Adama Barrow and his agenda. He blocked this. He voted against the draft constitution. And in an interview with the Standard newspaper, this is what he said about your commission. And I quote, "Gambians asked the CRC to leave Barrow to continue for 10 years. But they, that is the CRC, reduced it to 1. The people also asked them to close the age limit of the president. They decided to leave it open. So this is an indication that they did not represent the people, but the group they are serving. They only wanted to quickly get rid of Barrow."
Well, I call it an unfortunate statement coming from a leader, in our National Assembly. To be very frank, I can't put it any differently than that. And I don't know Samba, but I would be happy to sit with him and have that debate. You see, the difference between him making that statement and I, and my commissioners, is that we have the national statistics in our hands. He doesn't. But not only that, on the issue of on the issues that you raised, the Africa, I think they call it the barometer, whatever they call themselves, did an independent survey on the same subject. They confirmed what we found. The IRI did the same thing. They made the same finding. So this is not something we have just cooked up. These are based on statistics, and we have those statistics in place. All right. On the issue of the age limit, Gambians, it was one of those subjects where Gambians were never united on. Some said to us, no age limit. Some said to us, we want age limit. And we asked questions. If we have to have age limit, what would be the age? Numbers were miles apart. Some said 60, some even down to 55, some said 70, 65, 85, 80. They were just there. And some said, don't put any cap. Leave it to the Gambians to decide who they want. Whether a person is too old or not, Gambians have their minds to exercise in relation to that. So we said, look here, if we were to put a cap on this, whatever cap we put in, we'll be damned for it anyway. Even if we don't put a cap, we'll be damned. So we took a reasonable approach to this, taking into account the importance of leaving it open for citizens of whatever age, background, or whatever, so long as they meet the prescribed qualifications under the Constitution, to vie for political office or any elective office. That is to be left to the people. Let the people choose that. And we've seen in parliamentary democracies around the Commonwealth in particular, where that is basically left to the people. You've seen the recent case of Malaysia, where former Prime Minister Mahathir Mohamad, at age, was it 92, was elected to lead the country again, years after he had retired. We've seen in St. Lucia, years after the Prime Minister resigned and became blind, the people said, this is the man we wanted. They went for him. So you need to live there. You see, this subject, sometimes we tend to be very emotive about it. This is not designed to help or not help any particular individual. That was not our interest. We were looking at it objectively to afford every Gambian the opportunity to be able to contest elective office. All right? But in so doing also, we mapped out disqualifications. Because Gambians said to us, we want honest people to be leading us in elective office. They were very clear on that. So we had to put in those measures in place. So it's not just the qualification, we put in the disqualifications such way. They were not meant to help anybody or to dissuade any particular person from contesting elective office. But if somebody interprets it differently, I think I can only describe that as unfortunate. I mean,
how about the issue of you trying to quickly get rid of the president? This is coming from somebody who is an MP.
Yeah, but how could we get rid of the president?
By just affording him one time under the new constitution.
Listen, Lamin. We asked the people the question, and look at our issues document. It's there. We asked them the question, what should be the term limit of the president of this country? All right? We asked them that question. The second question we asked them was, what should the current term of the incumbent president count? Yes or no?
And the people said yes, the larger consensus.
The larger consensus, people said to us, whatever you do, we don't want people serving in the office of president for 2 terms of 5 years. There were a few who said 4 years and some 6 years. All right? And they said to us, that includes the current one. We just don't want anybody to serve in that office for more than 10 years. And this was a very difficult decision for us. And we conducted a lot of research, and we held a lot of discussions around this particular subject matter. A lot has been said about the Constitution, about that provision being unlawful or being illegal.
Or even retroactive, and you are a lawyer, that can be very problematic.
No,
you are a lawyer.
That's the point I'm coming to.
Yes.
If you see, a lot of people are talking about retroactivity. They really don't, understand or fully appreciate what it means. It's all too easy to say retroactivity is unlawful, but is it?
It can be.
Let me come to that. All right. What the position of the law. In fact, let me see this as one of the guiding rules under for the rule of law, is that laws must be capable of being known in advance, so that people can prepare and make their choices. All right. That's in the nature of the rule of law. From there emerges the principle of retroactivity, which says that you should not make laws, any law for that matter, that will have retroactive effect in relation to acquired legal rights or relate to creation of offenses that would affect a person. In other words, you cannot make an action that was committed before a law came to be criminal at that point, because you are trying to go back and penalize somebody for something that wasn't unlawful at the time. These are only 2 areas where the rules on retroactivity provide exceptions, but otherwise Parliament can enact retroactive legislation anytime they want. You look at section 100, subsection 2, paragraph C of the 1997 Constitution, which we have replicated in a different way in section 153 of the draft Constitution. It makes it very clear that Parliament shall not pass any law that has retroactive effect in relation to acquired legal rights or in relation to offenses. And then it goes on to say, in any other case, Parliament may pass a law to have a retroactive effect. So I want people to understand this distinction. All right? The office of president, office of parliament, of a parliamentarian, the office of a speaker, in fact, the office of any elective office, is not an acquired right.
Privilege, if you like.
Yes, it is not an acquired right. So what really have we taken out retroactively? What have we taken out? We have not.
If you
we have not acted unlawfully, we have not acted illegally, and the principle of retroactivity, I don't think, is being debated out there with the full knowledge of what the principle involves. And I just want people also to understand that parliaments pass retroactive legislation all the time. A good example is where you say this law shall be called, let me put it in crude terms, shall be called Lamin Jai, Act. All right? And then you say this law shall be deemed to have taken effect as of 1st January 2020. That's retroactive. But you can do that, so long as it doesn't affect acquired rights, and doesn't create penalties, offenses that were not offenses at the material time. In any other situation, it's perfectly and legally acceptable that can be done. Parliament does it all the time.
That's clear enough. But also, the one person that all eyes were on in terms of ensuring that this thing passes the National Assembly stage, it was the Justice Minister, someone that you closely worked with in this entire project and process. Really, what do you make of his role in all of this?
In a way, I sympathize with the Honorable Attorney General because he came at the tail end of this, when everything was done, and handed over to the executive. And I didn't have much dealings with him. I think I met with him only once before the bill went to Parliament. And as I said yesterday, I think for me, I'll consider it as harsh to expect that he would have been able to deliver on all the questions that people were asking, because frankly speaking, what ought to have happened? The House could have allowed the process to go on to the committee stage, where we would be invited to come and clarify, because nobody could have clarified this or explained the draft constitution better than us. So
then don't you think that it was a terrible mistake on his part to come there to try to clarify
those
questions?
No, I think he had an obligation. When you are in Parliament, all right, and I say this because I've served as Attorney General in a different jurisdiction before and a member of Parliament. When the House asks you questions, you should do your best to answer them. You don't dodge them or refuse to answer them. So I think what he tried to do was the right thing, try to answer the question. People may not be satisfied with his answers, and the fact of the matter is there was that provision in the CRC Act, and the process should have been allowed so we could come and explain all of their concerns and questions that they might have had. But I certainly wouldn't want to get into the debate as to whether the Attorney General could have done better, or he should not have answered, or he could have answered this differently. I think I know he can deal with this himself. I don't hold brief for him, and I don't need to, and I'm sure he's perfectly capable to do that for himself.
If you had a moment with the president over the issue, what would be what would you have advised him? Because clearly I see even the international diplomatic community wanted to get involved at a certain point, and all they wanted to discuss with him was for him to support this process to ensure that the National Assembly members did not reject the draft.
Yeah, I wouldn't be placed in that situation where I would sit with the president to advise him, because that wouldn't be my role. That would be the role of the Honorable Attorney General. as far as the draft constitution.
Not to really advise him,
was
but
concerned.
to give him your opinion as to what you think of his role in this, since this is a campaign promise.
Well, I don't want to get into that speculation because, frankly speaking, you know, I wouldn't get into that situation. I don't see myself getting into that situation whereby I could give him my opinion, because you see, whatever happens where I sit, you know, and my background and all of that, that could easily be perceived as providing advice. And having been a former Attorney General and knowing how the system operates, I wouldn't want to be seen to be doing anything that basically undercuts the Honorable Attorney General. I think that's something, you know, you have to demarcate those clear lines. You know, that is, you have to know that even if he were to ask me a matter of legal advice, the simple answer would have been, I think you need to consult the Attorney General on this. You know, it's not for me to say anything to provide legal advice, which has the effect of undermining the Attorney General. And he's the chief legal advisor to the President and to the government.
You are a lawyer, a justice at that. And one thing also that proved a little bit controversial has to do with the issue of paying judges for life. They will go home with the salary that they were receiving at the time of office. What do you make of that? Because you have a lot of people that say that's not fair.
Yes, I've had that debate, and we expected it. But again, you know, one of our mandates in the draft constitution, in the Constitutional Review Commission Act, is to ensure separation of powers. Within the ambit of separation of powers is to ensure judicial independence. And judicial independence entails a lot of things. It's not just putting in a provision and saying the executive must not interfere or parliament must not interfere in the judiciary. It has to do with the institution and how well shielded it is, how well it is protected to be able to take an independent stance in relation to determining cases. Courts are the last bastion of the average publican. You know, that's the last stage of hope for anybody who is aggrieved. The last thing we all want is to see a corrupt judiciary. We don't want that. I think some people will tell you they've gone through that history. You know, you don't want a judiciary where judges can be bought. You don't want a judiciary where judges are influenced by money. You don't want a judiciary that is manned by incompetent judges. All right? So what do? You find a mechanism to encourage the brains in the legal practice to come and serve in the judiciary. Because if you don't do that, what is going to happen? You end up with people that ordinarily you wouldn't have liked. So in order to do that, you need to have a good remuneration package. All right? And if you look at it beyond that, and I'm saying this knowing that whatever I say, I'll be damned because I'm a judge.
You are a judge, of course.
But
so
the mere fact that I'm a judge, and under the CRC Act, the chair of the CRC could only have been a judge. It could have been the Chief Justice or any other Superior Court
Court judge.
All right, that's the way Parliament itself enacted that. But leaving that aside, if you look at the current public service, the retirement age is 60. The retirement age for judges is 75. So by the time you retire at 75, you probably have only a few years to live, not much opportunity to receive much pension. So what do? You create a package as part of that process to encourage judges with judicial experience to continue serving up to that age. It is 75 under the current constitution. We retain that under the draft constitution. But we did not stop there. We looked at other countries, how they dealt with the matter. Ghana has the same provision. In fact, Ghana and Nigeria have more generous provisions for judges than we have provided. But I want other people to also understand that for the executive, similar provision exists. What we call, I can't remember the full name, but it has to do with former presidents, their salaries, allowances, retirement benefits, and things like that. There is specific legislation on that caters for that. There is a similar law for parliamentarians, which is called the National Assembly Salaries and Allowances Act, something like that. There is no equivalent legislation for judges. None ever existed in this country. So we looked at other areas. So since we're dealing with separation, but we want an independent judiciary. This has nothing to do with me. I will die and leave this behind me. All right? What we want is a judiciary that is independent, that can be looked up to, that can exercise the level and the desired level of independence, so that the average person or any litigant going before the courts will be satisfied and will have the confidence that they're going before a judge that they know is clean, and will serve justice, But if you hear people saying, oh, X went to see that judge and he took money and things like that, the entire judicial system goes into tatters. It becomes a problem. One of the first things Lee Kuan Yew of Singapore, the first Prime Minister of Singapore, who did phenomenally for his country, the first thing he did was pay all judges $1 million. He said he doesn't want a corrupt judiciary. All right? He wants a system, and he knows that the judiciary is very crucial to national development. He knew that, and they are properly paid. Other countries, that's what they've been doing. So that is the reason for that. And like I said, we debated on this, and we said, look, we couldn't even go to where, for example, Ghana and Nigeria have it, because we knew there would be problems. The other thing also is we put in the draft constitution similar provision for the president. All right? We said he could retire in his salary, it's not taxable, and all of that. Because we felt that when we have presidents, we need to have them retire or demit office with dignity and live in dignity. No matter what happens, they've been our leaders, and we must give them that respect, we must give them that honor. So we put in those provisions. Last thing you would, I don't know about you, but I'll be ashamed to walk the street and see my former president begging, or my former president come to me asking for money. We need to provide a mechanism and put politics aside, put sentiments aside. All right? If we want a system that's going to work and serve us for the longer term to come, we need to recognize certain realities. And this is one of those. We may not like it, but it's one of those realities. I hear people say, if you're doing it for judges, why are you not doing it for doctors? But fact of the matter is only judges in this country that retire at 75. But even worse, or good, depending on how you look at it, judges cannot practice when they retire. Under the draft constitution, we made it very clear that if you are a judge and you retire, you cannot go back to private practice. You can't. The reason is very simple. You don't want a judge there trying to build a practice for the day he retires, he or she retires. You don't want things like that. That compromises the entire judicial machinery. You don't want something like that. So they have restrictions. It's not an open entity. It's not like, yes, you retire on these benefits and then you can practice. No, they are restricted. They cannot practice. Yet they have to live. They have families to take care of. So I think people need to understand all of these variables, and I don't think people do. And I certainly wouldn't blame anybody who is making an argument on this and doesn't, wasn't aware of all these variables, because at the end of the day, you have to look at what the ultimate objective is: an independent and incorruptible judiciary.
Now, in your opinion, where do you think this development has left us as a nation? Now you have some people who think that the document can be brought back. You could go and then sit and then discuss and come to a compromise, and then the document can be revived. You have this other side that says, okay, it's all over. Now we are left with the 1997 Constitution. In your opinion, where has it left us?
Well, a pessimist would say we are done and there's no future. But the optimist in me tells me that all the parties concerned in this do want a new constitution of some sort. That all parties genuinely want what is best for this country. And all parties genuinely want to respect the wishes and aspirations of the people of this country. So what I see potentially, or what I hope could happen, is that the players that have this agreement on the draft constitution will be able to get together, talk to each other. That's the first step. If you disagree with somebody and you don't talk to each other, you'll never resolve your disagreement. So my hope is that they'll be able to get together and discuss their different perspectives on the draft constitution. And my hope also is that they do not leave out public opinion. And we have that information. Beyond that, or embraced within that, is the importance of ensuring what is in the best interest of the public. The public interest must always take center stage, because the majority of our people in this country are not as learned as you and I, and they rely on you and I to make them better, to help them. And that's always what we must bear in our minds. Even as politicians sit down to discuss, they must always reflect on the average person in the village sitting there struggling, and look at what will be best for this country that can result in elevating the livelihood of that person.
Finally, what is left of Chairman Jallow and his CRC?
Well, as I said yesterday, I mean, we demit office formally on the 22nd of this month, and then we will leave the secretary, who will then wrap up a number of things and hand over everything to the Ministry of Justice. As for us, we move on. We all came from our own backgrounds, our own jobs, which we continue to serve in, even as commissioners. So we just go back to that, and then those that are free birds continue to fly.
And let me quickly squeeze this in.
Yeah.
Just today, I heard that the government has started taking back the vehicles that have been given to you.
No, I don't think it should be said. I wouldn't say that. I mean, it was one vehicle, which is one of our pickups, and that is standard practice, I think, in government. When the president is going in a tour and they need vehicles, so they pool vehicles that are available, and then they include them in the fleet. When we were going on our internal public consultation, they did the same thing. They were stopping other vehicles to give them to us. So no, I wouldn't say that we were being targeted on that. I'm even surprised this is in the public domain, because this was brought to my attention, and I said, you know what, if we can let it go, let it go. All right. We are at the time where we are winding down, but no, I wouldn't say that we are being targeted. If we are being targeted, I'm sure you'll be the first to let me know.
Chairman, do you have any final comments?
Thank you, Lamin, for this opportunity. And what I would just like to conclude with is, we've gone through these 2 years, been very difficult periods, but we are satisfied that we've done the people's work. We are satisfied also that the people of this country, both here and overseas, have come forth and shared their candid opinions with us. We might not have agreed with all of them, as reflected in the draft constitution, but I want to thank particularly those who said, and they were very clear, including your own GPU.
Yes.
Who I understand came with a huge battalion and cameramen, yes, hoping to intimidate us.
Yes.
And it didn't work. But nevertheless, still saw wisdom in accepting the draft constitution. And for me, that's a mark of leadership. And we do need to also appreciate the fact that there will be those that will continue to oppose, those that will continue to be dissatisfied. We should not cast them aside. We must always put them around us, all right, in due course. And that's how laws function, whether it's constitution or statute. Parliament always, working with the executive, has the opportunity to enact laws, to amend laws as well. So if something is there today, it's working for 10 years down the line, it may not be as workable, or there could be a better solution to it. Then you introduce amendments and move on. Well, if we insist that what we say is what must go in, then what you end up is creating an atmosphere of rigidity, and that doesn't help the process going forward. I have absolute confidence that the government does have intention to come up with a new draft constitution. I have absolute knowledge, based on the past 2 years, that Gambians do want a new constitution. I want all of us to continue the dialogue on constitutional development. If there is one wish I have for this country, it is that we shall continue to live together as one family. We can disagree, that is in the nature of community, but we must at the same time respect our differences without blowing it, without being mean, and without being, without allowing ourselves to separate and not talk to each other. I think that will be a sad day for this country. I think we need to continue that dialogue. We need to be a more cohesive community, society, and we need to maintain the unity and the peace that we have in this country. The reason you and I are here speaking freely is because of that peace we have. If it wasn't here, we probably will be hiding somewhere, And I don't want us to take these things for granted. I can, sit with you and say a lot of things. Mm-hmm. They should not be taken personally, And you may ask me questions, and I may be wondering in my head, why are you asking me this question? I don't take it personally, So we need to, I think as a country, we need to relate to each other. We need to talk to each other more and more. And let's not put politics over the will of the people. A politician might say, well, you go and sit down. You don't know what you're talking about. But ultimately, and I've worked with politicians practically all my public life. All my work has been in public life, here, overseas. And I've worked with legislators. I've worked with cabinets, and things like that. The fact of the matter is, if you don't make the people the centrality of your projects, make them the centrality of your administration, you end up alienating them. And that is what brings about dissension, and it degenerates into something else. I do not wish for that for this country. I hope, and I have absolute confidence, that our leadership will continue to hold us together as one family, and also will accept our differences and continue to allow the open space that we all needed and we have to dialogue freely, without fear or favor. I think that will be a great thing and continue to be a wonderful thing for this country.
Chairman, thank you very much for your time. We appreciate
Thank you, Lamin.
Much appreciated.
Thank you.
That is the chairman of the Constitutional Review Commission, Justice Cherno Sulayman Jallow, speaking to us there, which will mark the end of this interview. Thank you for being there. Until next time, goodbye.